in this conversation for National Make a Will Month seminar. Give us a few minutes. We want to make sure that we are able to give you an opportunity to uh, set your screens up as well as share information. So we're going to give a few seconds. So we will be starting in a second. But thank you for participating in this conversation on a Sunday. We know you can do anything in the world on a Sunday, and you chose to ensure that you have this conversation with us. So we're going to give you a couple of seconds before we begin. And also for housekeeping rules, make sure you ask your questions. Use the chat box to ask whatever questions you think that you need to ask regarding this very important webinar. So let's get started. Good afternoon, everyone. My name is Al Tariq Kinney. I serve as the Essex County Surrogate here in the state of New Jersey. Essex County is one of the largest counties in our beloved state. We wanted to make sure that we have this conversation, which is critically important to the lives of people. It doesn't matter who you are, where you live, what your background is. This is a very, very critical, important conversation. So estate planning is something that at times can be an uncomfortable conversation. We wanted to make sure that this conversation that we're having today, you get the opportunity to ask questions. We have some very, very important guests here with us to navigate this conversation. So let me just give you a couple of things why this conversation is critically important and why we decided to have this. 32% of Americans in this country will unfortunately die without a will. And in the last, there was a poll that was taken, less Americans today have a will than in 2006. So this opportunity for us to have this conversation is to encourage you to ensure that you take estate planning very seriously. Over the next 25 years, about $62 trillion of assets will be transferred from the baby boomer generation to the next generation. And so this conversation is important. Because we see in real time what is actually happening. We've actually seen Nipsey Hussle, which was a very young man who unfortunately passed, and we see family members are struggling to divide his assets, as well as the most recent incident, which is DMX, one of our, more popular, famous artists, and his unfortunate demise. And because he had a large assets, we see family members are fighting, are struggling to figure out exactly what happens next. And so this conversation is critically important. And that's why we decided to have it today. So thank you for participating. Thank you for being a part of us. But we have a special guest today. And this gentleman, you probably know him. I know him, from The Best Man, the Matrix franchise, Oz. He had a great showing at Felon. We have some questions about some of the things he did in Felon. So we're going to have some questions about that offline. But this gentleman right here is an actor, producer, a father of three, husband. We are happy to have Harold Pernod, who's able to share his story, what brought him to Essex County Surrogate's office, who unfortunately lost his brother. And so if you don't mind, we would love to hear from you. Thank you, Harold.
Oh, okay. Thanks, Alteric. That's a kind and generous introduction. Hello, everyone. How's everybody doing out there? I'm so excited that they invited me to speak today or to be part of this seminar. This is something that's really important to me, not just because I lost my brother, but we have been talking in my family a lot about wealth building and building wealth forward and making sure we plan for our family and moving it forward, not always back. So I'm really interested and happy to have this conversation. I'm here because early last year, I lost my brother. We imagine it's to COVID, but because it was during the pandemic, there was really no way to get him analyzed by the doctors in a really full and thorough way. Anyway, my brother was a very young man. He was really smart. He was trying really hard to amass, some wealth and things like that. And but he wrote his will on his cell phone, and he hadn't gotten around to actually making it legal. And he suddenly passed. He was a man in his early 40s. and he was missing. We eventually got the police to go to his home, and there we found him where he had passed away. And if that's not traumatic enough, his girlfriend then didn't know what to do with any of the things that he had. He had some stocks, he had his apartment that he owned, and all these things. And so my wife and I, who are often really, like I said, very interested, we're always kind of talking about that stuff. We took on the task of trying to figure it out. And because we live in California, we really weren't sure of how to get things done in New York. And that's where young Al Turek comes in the office of the Essex County Surrogate Court. They helped walk us through all the things that we needed, every single question we had, where we had to go, the things that we had to do. And it was quite difficult. And it really it reminded me that it's something that I have to myself make sure that I do. I didn't have a will as well. And literally, we are in the midst of planning all of those things now because of this thing that happened with my brother. So I'm here just to tell you, in real life, like, you can just slip up, just decide, like, oh, I'll get to it, and then you miss it. And so we are here with a lot of super intelligent, smart, and very precise. They know exactly in their counties what you need to get done. So I won't continue to talk. We have a lot. I think Judge Toledo is probably going to speak next. And so I am going to stop talking. I'm really happy to be here with all of you. Okay, thanks.
Harold, thank you so much.
Thank you, Harold, for sharing your personal story. We truly appreciate it. And also taking time out of a busy schedule to participate in this conversation. I want to introduce a young lady who is a judge out of Passaic County, who is a graduate of William Patterson and Seton Hall University. Her talents have led the county of Passaic, that consists of 501,000 residents, over the past 10 years serving in this position. Let me introduce to you my fellow judge, Judge Bernice Toledo.
Thank you so much. I'd like to thank Judge Alturi Kenny for inviting me to participate. Essex County, my distinguished panelists, and of course Harold Perrineau for sharing his experiences to let everybody know that this can happen to you too. So the Surrogates Court, people hear the term, they don't really understand what it is. And you think the term surrogate and you think, well, you know, a mom who has babies for somebody who can't. Well, surrogate means somebody who does for somebody else who cannot. And what we do, what the Surrogates Court does, is it empowers people to stand in the shoes of those who cannot. Among that class of people are people who passed away, because your loved one, let's say it's your parent, your sibling, they may be gone, but their stuff is still here. Their house is still here, their car. In the case of Harold's brother, his stocks were still here. So what do? You can't just go to a place where they had their assets, to motor vehicle, for example, and say, well, you know, that's my husband's car. We can just transfer it in my name because I'm the one that drove it anyway. They don't want to hear it. You can't junk the car. You can't sell the car. You can't transfer or re-register the car unless you can stand in the decedent, the person who passed away's shoes. That's where the Surrogates Court comes in. We empower you so that you can dispose of a person who passed away's belongings. Now, it's a conversation that people don't want to have. Planning for the end, planning for our death, writing a will. They don't want to talk to their parents about it. Maybe they think that their parents will feel funny about it, them asking about assets or planning. But it's kind of like the Matrix, right? And Harold can speak to this. The red pill, the blue pill. You got to pick your poison. You have to get in there and decide and plan. You can veil yourself in the illusion that you're going to live forever, and you don't need to do the planning, but it all comes sooner or later. It will come. It'll either come prematurely, way too soon, like it did for Harold's brother, or it can come in, let's call it a timely fashion, when you're in your advanced years, but it's always too soon, and we're never quite ready, are we? So we want to make sure that we plan in a particular way so that we take care of our loved ones. just so you understand how significant the surrogates court is and how sure death is and the process is, know this. In Passaic County during the pandemic, which started in March of 2020, right around there, and for the 10 years I've been in the surrogates court, we have about, I don't know, 300 deaths per month, right? 300 deaths almost invariably since I started for 10 years. In April of 2020, at the height of the pandemic, we had 1,320 deaths. It was 400%, 4 times our normal volume of deaths, and it was up for and elevated for a very, very long time. So we have to plan for the end. We have to plan for our future to make sure that our families are taken care of. Thanks.
Thank you, Judge Toledo. Thank you for sharing that story in terms of the number of deaths that you experienced in your county, and which is truly felt throughout the state. Let me introduce a young man who I have the pleasure to work with, CPA, Science High School graduate, I always say that. Also a Rutgers University graduate and a dear friend of the court, because he is one of the hardest working people in our court. Let me introduce you to Devera McDougal, our Deputy Surrogate for Essex County.
Thank you, Surrogate Kenny, for the introduction. So 2 things I want to do. I want to first thank Mr. Harold Pernay for coming on and telling his family story. It's important for everyone that's watching us and who will watch this later on to hear his family story, because we all, like he said, we think we have time and all of a sudden things happen. And to kind of, merge that with Judge Toledo, she talked about Passaic County and COVID, and it appears, unfortunately, Harold's brother passed away from COVID. And so, one of the things, because this is National Make a Will Month, so I have to tie it all together, of course, to that. One of the things that, we've been doing even before the pandemic hit is going out, I will say preaching to everybody about the importance of a will. Well, the pandemic has showed us the importance of needing a will. Not only needing a will, there's other important documents. The surrogate earlier said estate planning. And I'm going to let our next guest talk about some of the other important documents that came in handy for many families during this pandemic and will come in handy thereafter, because it's part of the estate planning. You're going to hear the word estate planning. It's also family planning. Harold talked about the fact that building generational wealth. All of this, we might use different terms, but basically it's planning for the inevitable, planning to help your family out. So, I'm not going to take up much time because I want Crystal to talk about wills, the importance of will, what are wills, the other important documents that people should consider when they start thinking about the importance of a will. And we're going to also have some questions that people have asked us in advance. But as Surrogate Kenny said, we want to make this interactive. We want to start this conversation. And for those of you that already started the conversation, we want to help you continue this conversation with your family members. So by all means, give us questions so we can answer those, because we say this all the time, because Crystal and Judge Toledo has helped us plenty of time. But when you have 3 lawyers in front of you and you're getting this information for free, you better take advantage of it. So with that, I'm gonna turn it back over to Surrogate Kenny so he can introduce Crystal, and so she can go ahead and tell everybody the importance of having a will. Thank you.
Thank you, Devera. I truly appreciate it. This next guest is Crystal West Edwards, who is the principal of Porzio, Bloomberg, and Newman in Morristown. She has an extensive experience in estate planning and estate administration. But what I found was most interesting is Crystal is the only African American in New Jersey who is certified as an elder law attorney by the ABA accreditation of National Elder Law Foundation. So I just want to introduce this young lady, Crystal West Edwards. She has a wealth of knowledge, and we truly appreciate you. And also, she most recently experienced a loss in her family, and during these tough times, she decided to participate in this conversation. So our hearts are with you, but thank you, Crystal, for participating in this conversation.
Thank you. Thank you. So, it's never fun to talk about the death and dying process, right? Like nobody really wants to sit on a Sunday and sip tea and drink coffee and talk about what's going to happen when they die. But it's, as Judge Toledo said, it's a fact of life, and we just have to plan accordingly. So when you hear the term estate planning, like what is that and what does it really entail? Some of it is just thinking about what it is that you would want your loved ones to do when you're gone. But then you're also pairing that with the legal documents that make it enforceable. So when I think about an estate plan, I'm primarily talking about 3 documents with a 4th honorable mention: wills, powers of attorney, and medical directives. I'll do those in reverse. So a medical directive, that's where you're appointing someone to stand in your shoes to make medical decisions for you if you can't make them for yourself. If you have strong convictions about whether or not you want your doctors to pull the plug or to do everything humanly possible to keep you alive, if your doctors feel that there's no medical likelihood, right, short of a miracle, that you would survive, would you want your loved ones to authorize your doctor to pull the plug or do everything you can to keep you alive? And then it also will typically say how you feel about organ donation and how you feel about other things that may have a religious impact to you. For example, if you have certain beliefs that do not allow you to accept blood from another person, that would be something that we'd have in a medical directive. The power of attorney is similar to that. It's where you're appointing someone to stand in your shoes during your lifetime to make legal and financial decisions for you. That one doesn't require you to not be around or not be able to make decisions for yourself. And that can be a good or a bad thing, right? So some people will say, I don't want to appoint my daughter now as my agent under my power of attorney. She could give away all of my money tomorrow. Well, yeah, that's true, right? But so we shouldn't appoint her if you think she's going to give away all your money tomorrow. But in addition to that, having a power of attorney that's effective immediately can be very beneficial to you, because in a crisis, your loved ones do need to be able to act on your behalf. So for example, if you have my personal example, if you had a big closing that needed to be done so that you can move into a house or sell a house, and now you had an emergency of some sort and you can't attend to those affairs on your own, even though you have sound of mind to do it, if you've appointed someone else, that someone else would be able to stand in your shoes and business to kind of operate. Those 2 documents are important during your lifetime, but they mean nothing when you die. So people will call me and they'll say, hey, I'm really sorry. My mom just passed away and I'm her power of attorney, but the bank won't give me access to her money. Well, spoiler alert, your mom's power of attorney died with her. And so therefore, at that point, the person who can act on her behalf is the person that the surrogate's office has authorized to do so. And that's either because you have a will that appointed someone as your executor, or you did not have a will and you open what we call in New Jersey an estate administration process. So now what's a will? So a will primarily, right, it says where you want your stuff to go, who you want it to go to, and how you want it to go there. I appoint my son as my executor to marshal my assets. So collect the assets that I have, pay my debts, pay my taxes. Those things come off the top first before anything else. And then when all of my stuff is cleaned up, I want you to pay the rest of my estate to whomever beneficiaries I have designated. A will only controls things that are in someone's personal name. So if they have joint accounts or accounts that have a beneficiary designation, like stock and some brokerage or investment accounts, but definitely IRAs and 401ks, those things go by your beneficiary designation. Life insurance goes by your beneficiary designation. However, your will controls the things that were just titled to you. So now the honorable mention, a trust. So similar to Judge Toledo's explanation of the surrogate's court, you can consider a trust in the same way. It's like putting an invisible box around money and then handing another person that box. And so the invisible box around the money is the trust. The person that you hand it to is the trustee. And that's the person who you're saying, here's money. I want you to hold it for the benefit of someone or some people. And it's the trust agreement, or sometimes a trust is inside of a will. That's what will say how you want them to manage the money. So let me give you an example. So I have small children. And my will says that if my husband does not survive me, my estate is divided between my 2 children. Well, my kids are 3 and 5, and there's no way that they're going to be able to manage $5, let alone $5,000. So what that trust does is it gives the responsibility to another person to manage my children's money. And then that trust agreement says how I want that person to use my money for the benefit of my children. I want you to pay it for their health, education, their maintenance, and their support, right? For them to be able to live in a way that they would if I were still here. Trusts are critical in 4 scenarios, critical. The first would be for minors. The second would be for our loved ones who may have a disability. Our loved ones who have intellectual and developmental disabilities in particular are able to qualify for a significant amount of government benefits that can assist with covering their day-to-day life to be able to live meaningfully in the community. The last thing that you would want is for the money that you intended to be a blessing to somebody else to disqualify them from the benefits that they very much so need. And so having a trust is a way to be able to use your money to further enhance their life while at the same time qualifying for those benefits that they need. The third time that it's really important is if you have people of advanced age who you want to leave money to. Similar to our disability population, our senior population at times does require assistance through likely oftentimes going to be our Medicaid program or our program through the Veterans Administration that helps pay for that 5-figure per month cost of being in a nursing home setting, right? So if you have money that you want to benefit seniors, I'd recommend that we consider a trust for that. And then the fourth time would be if you have a loved one who has a creditor problem, right? If the IRS is coming after your kid, you might want to still leave some money to your kid, but not in a way that the IRS will be able to get the money that you intended to be for them. So if they have some creditor concerns, we should also consider a trust. And the last thing that I'll say on this is about guardianship. This is probably the most difficult discussion to have with couples who have children that are minors. No one envisions passing away before their kids even reach the age of 18, but it does happen. And so in your will, a will should say who you want to serve as guardian of both your children's person and their property in the event that both natural parents pass before their 18th birthday. And that is estate planning 101.
Thank you, Crystal. I appreciate the information and the that's powerful. That's the reason why you always have done a tremendous job in terms of providing information regarding this very, very important topic. We're going to transition real quick. We have some questions that came in, and so we're going to let Harold snag some of those questions so he can present to Crystal and DeVero. I know Bernice, Judge Toledo jumped out. She's going to jump back in a second. So we're going to turn it over to Harold.
You have to unmute.
Good. Thank you, Harold.
You think I remember any of this stuff? I'm theoretically, I'm the professional. I'm working on borrowed equipment, and clearly I don't know what I'm doing. So I have a few questions that were sent in advance. And so I will just ask the question, and whoever would like to answer it, they can answer it. This question is from someone named Wentworth. And the question is, what is needed for a will to be valid or legal? What is needed for a will to be valid or legal?
So I'll let Crystal handle that one.
I was going to say, I think that Judge Toledo should handle that.
Okay, pass it on.
So I'll take it. Thank you. So for a will to be valid, you would need an original will. Photocopies are not acceptable. When you have a photocopy of a will, the presumption is that the original was destroyed, and that if the testator had a will that they wanted you to find, you would have found it. So an original will with your signature as the testator, the person who was writing the will, and 2 signatures witnessing your having made this will. That's mostly the step. That's a valid will. If you have a self-proving affidavit, and in the last several years, most of them do have a self-proving affidavit, it's even better, which is a notarized statement by your witnesses saying that they saw you sign it, that you were of sound mind, that you were over 18 years old, and that you were not forced to sign this will. So when you have your will, original will, with your signature, your 2 witness signatures, and the self-proving affidavit saying that you were of sound mind, no bridge, then we don't have to chase witnesses at the time of your death to assure that they were the ones that signed it and they saw you do it. So it's pretty straightforward. There's really not that much to it, but we also have to make sure that the will is in good condition. So if it's tattered, markings, cross-outs, that could invalidate a will, which would cause a lot more obstacles on the shoulders of the person nominated to take care of your stuff.
And the only other thing I'm going to add to that is in New Jersey, wills are not digital. They have to be hard copies. That may change, but that's where we're at today.
I was going to say, why don't you say yet?
Right. That's where we are today.
That's really super important because, that's one of the things that we found out, all those things that had to be hard copies, things that you had to sign in front of a notary, like it really is important to know these things. So I'm going to do a little pivot. I have a bunch of pre-asked questions, but somebody asked a question here. Mr. George Stillwell said, he asked me, would I consider having people make a will of their own or with an attorney? And I'm going to let the attorneys answer the question, but I'm going to say for myself, you hear how smart these people are. You hear the language they're speaking. For me, it's like they're speaking another language. I'm doing a lot of like, what'd you say? What did you say? So I think, Mr. Stillwell, the idea is to have people who really, really understand what's going on, have them do your will. But I will turn it over to our esteemed panel and have them answer the question.
So I'll take that one. So the short answer is you should absolutely have an attorney do your will. The realistic answer is that we live in a society where information is at our fingertips and people will feel inclined to do it themselves, right? They'll DIY it. And if someone decides to DIY, I strongly, strongly recommend that at a bare minimum, you see an attorney and have them review it, because truly you do not know what you do not know. And all of the wills that I have had to go to court to interpret in the last 5 years have all been DIY wills. So why, right? It's going to cost more money for us to file a court application to interpret your will than it will be to actually see an attorney to prepare one. So that's my 2 cents on if you should have an attorney review it.
Can I add to that?
Please.
So Ms. West said something about taking it to court to interpret the will. What that means is, well, let me explain the process. When you come to the surrogate's court, that's a county level court. And if you have a will and it is in order, it is a very easy process. You present the will with a death certificate with a gray seal, the list of assets or the value of the estate. You have your court fees, and you're done. You know, depending how long it takes that court to process it, you should be okay, barring any family dispute or somebody contesting the will, right? It's pretty easy. What Ms. West is talking about interpreting the will is, if you have a will that's defective, sometimes it's almost worse than having no will at all, in some cases. But in all cases, when you have this defective will and you have to get it admitted to probate, now the surrogate's court can't admit in an administrative proceeding. Rather, you have to file a complaint and an order to show cause. You have to go before the court, provide proofs, maybe some testimony, credibility determinations have to be made, and the will be admitted in parts, in whole, not at all. You know, you're throwing it up to chance, and you are making it a very expensive process. So when you go to the surrogate's court, if everything is in order, we can have you in and out, and it's administrative. If not, you'll go to superior court, which is a state court, and that's where the problem falls.
And I just want to make sure everybody understands that today we are talking about the surrogate court in New Jersey, and anything that Crystal or the judge or anybody else says, this relates to New Jersey court rules, New Jersey laws. There may be a question coming up later, but regarding the difference between New Jersey and other places. So I just wanted to make that clear. Also, I just want to kind of be a little bit of a lawyer and make a disclaimer. So today, what we're providing you is information, and we hope information that will allow you to have conversations with family or continue those conversations. But by all means, I want everybody to understand that we are not your lawyers. We are not providing you with legal advice. We are providing you with legal information. I have to do that because I don't want, because sometimes people have the misunderstanding. It's kind of sort of what Crystal said. You know, we are in a day and age where everything's at your fingertips. This is at your fingertips. But I wanted to be clear that we're just giving general information, because if you were to go to Crystal, she would sit down with you, interview with you, and provide a plan that was specifically tailored for you. Today, we're not doing that. We can't do that. So I just want to also just point that out before we move along. Thank you.
Thank you, Deputy McDougal. Thank you. So this next question I have is from Cherokee. The question is, I have a Robinhood investment account. Can it be written into a will to have those stocks or the sale of those stocks left to my children?
Can I touch on that? Just quickly?
Please.
So it's wonderful that he has a Robinhood account. This is, for those that don't know, that's an account that's allowing regular lay people basically invest in stocks. Like Harold was saying earlier, planning for future, just like his brother was doing, making some intergenerational wealth. The thing with Robinhood, though, is that you're not allowed a designated beneficiary as you would in a life insurance policy, for example. The Robinhood accounts have an underlying bank account. So if you pass away and you need access to those funds, the funds may go back to that bank account, and whatever the terms of that bank account would dictate. So if there's a payable on death, it would dictate. If there's none of those, can you indicate in your will that you want your Robinhood funds to go to that person? Well, sure, you can. It's not going to happen automatically, though. There's a space in between. And if you have no will, it's also not going to happen automatically, because there's no provision for a designated beneficiary. There's only something, I think it's called a trusted person of confidence, with whom Robinhood can speak in case you're unavailable or you've passed away. But that's an excellent question, and A+ to all those AMC diamond handlers who are getting into the stock market these days with Robinhood.
Anyone have anything further to add to that one? Okay, fantastic. I'm going to move on. This one is from the White family. It says, if I make a will in New Jersey, one state, and move to another state, will it be valid in another state? What crucial steps, information, and or statements would aid in the will to be acceptable in another state?
Okay. So a will, I'll start that one. So a will that's validly executed in one state, right, is effective in another state, but that doesn't mean that that will is going to accomplish your goals in another state. And I'll give you an example. In the great state of New Jersey, we have something called inheritance tax, folks. We have a tax on the amount of money that passes to someone else, except for we do not tax charities. We do not tax spouses or parents or grandparents, and we don't tax children, grandchildren, or stepchildren, but we do tax step-grandchildren a lot. So we have an inheritance tax. So you say, listen, you know, I have one child and my child is cool, but I really love my 8 nieces and nephews. Like, those are the gift and the light. If you want to leave 80% of your estate to your nieces and nephews in New Jersey, you're going to pay you're going to be dead. Your estate is going to pay a 15% inheritance tax, right? So you may develop your will in a way that has your inheritance tax paid from their share. And now you pick up and you move to the great state of Pennsylvania. And you never really talk to anybody about your estate plan. You got this will you did in New Jersey. Now you're living in Pennsylvania. And Pennsylvania not only has an inheritance tax, but they also have an inheritance tax on money that goes to children. So now the allocation that you set up to make sure that this one gets this amount and the taxes get paid may be all blown after your passing, simply because you didn't know that there's also an inheritance tax for children in the new state that you live in. The law is very unforgiving. I don't know if we really haven't really talked about that, but there's a saying of, ignorance of the law is not an excuse. It's really harsh, but that's what it is. So even if you didn't know that something was going to occur, you're stuck with it. So if you have a will and you go somewhere else, same thing with a power of attorney or a medical directive. If you have your planning in place and you go to another state, just sit down with an attorney, have a consult, have them review your stuff, and make sure that it checks all of the boxes that it needs to check in the new state that you're going to.
Fantastic. Thank you, Ms. Edwards. Thank you. Another question from the White family, I think is quite important. It said, what are some of the essential components that should be part of a will?
All right, I can start that, but it's such a loaded question. So let me debunk a theory. Okay, there's a theory that there is a will called a simple will, right? So people will call and they'll say, hey, I want to schedule an appointment with Ms. Edwards, and I really just want a simple will. I'm like, all right, cool. So whenever you see an estate planning attorney, they're typically going to start your relationship after having you formally hire them by signing a contract. Spoiler alert. The next thing they're going to give you is a questionnaire, a full financial questionnaire. And they're going to want you to say what you have, where is it, how it's titled, who it's owned by, etc. If you sit in a lawyer's office that's going to prepare a will for you and they don't ask you for your financial information, you should kindly pick up all of your pearls, your purse, your bag, whatever you came with, and you should leave, because that person honestly may write a will, but probably doesn't do estate planning. You really need to know what your stuff is. So, they'll sit down and they'll say, I have a simple will. I'm like, all right, cool. No problem. Tell me about yourself. Well, I'm divorced and I've got 2 children from marriage 1, and I'm getting ready to get married, and we plan on having, a family as well after that. And then, oh, by the way, that person that I'm dating, he's got kids who I love like my own. And then it just kind of goes from there. And whatever was simple, I don't know what the person had in their mind is simple, ain't so simple anymore. Or they'll throw in, and, I want to leave something to my brother. He has autism, but, he doesn't really need much, but I just want to leave him a little something. And now I've got a will that has an allocation for children that are going to be outside of a new marriage. Depending on when this new marriage is going to happen, I might want to contemplate that the new marriage is going to happen to avoid 2 wills, right? So I use that example just to say that the components are going to depend on your family circumstances. But the biggest thing is to not assume. Whatever it is that you want and that you feel your family knows, it needs to be in writing. So typically it will say that you've got some stuff. You've got your phone, your watches, your computers, right? Your random, what we call tangible personal property. So you want to say something about where your stuff goes. That stuff may not have great value, but that stuff can be what your family fights about when you're gone, right? Who grandma really loved this painting that she got from Home Goods for about $12.99, but it was always in her house. And so I want that, right? So something about the stuff. Something about property, your house, especially if you have children or other family members. We live in a part of the country that has multifamily homes. And so maybe mom was in unit 1 and the kids are in unit 2 and 3, and now mom is passing away, right? What's going to happen to that house? Is the house going to be sold and the assets distributed? Or is the house going to be divided up among the kids? What happens if only one of the kids lives in the house and not the other? So you want to say something about real property. Anything that you want to specifically give to someone. I want $10,000 to go to my cousin. I want $15,000 to go to my niece. I typically strongly discourage people from leaving dollar amounts, because dollar amounts like that get paid off the quote unquote top. And so if all you have when you die is $25,000 and you left 10 to one person and 15 to another, your other beneficiaries who you wanted to leave stuff to have effectively been disinherited. So we like to promote people to leave their stuff in percentages, right, as opposed to dollar amounts. So you want to say that. And then if people have a minor child or a child for which they serve as guardian for after that person has turned 18, then the will should certainly say who's going to serve as guardian when you are now gone. And one provision that people skip or don't really think about because it's hard, but I force all of my clients to, is what I call the taker of last resort, the ultimate beneficiary. You have your estate going to your spouse, after your spouse, your kids, and then your grandkids. Well, what happens in the unlikely situation where everybody is gone? If everyone is gone, where do you want it to go? Are you charitably inclined? You want to benefit cousins, friends, whomever. So it must be signed. It must be witnessed. And as Judge Toledo said, we really, really, really want it to be self-proved. So notarized with a statement of your witnesses that says that they were there and that they can attest to it being your true signature.
And the only thing I want to add is you wanted to say, and I'm going to use the legal term that Crystal used, you want to know who's in charge of your stuff when you're gone.
Oh,
so
yeah.
You have to name an executor. The sexist way to say executrix if it's a woman, but if you say executor, you're fine. So you want to definitely say who's in charge of your things. I would also suggest that you name 1, 2 possible successors, because the first executor, Crystal likes us to use 3, because the executor you initially named may not want to do it, or they may predecease you. And so as we talk about the will, this is your wishes, what you want. So you don't want the court to decide who's going to be the next person in charge of your estate, or people fighting over it. So you want to definitely name your executor. The other thing that is kind of sort of near and dear to the Essex County Surrogate's heart is you want to make sure you name a representative to handle your burial. Because we've unfortunately, and I know Judge Toledo probably seen this too, unfortunately, people don't have a will, and they pass away without a will. You have family members that don't want to bury them, and the body remains in the ME's office. Or if you don't name it in the will, you have to go to, as she talked about, Superior Court, which costs you more money because now you have to pay an application fee of $175, plus you may need to get an attorney. So definitely name somebody who's going to be responsible. And the last thing I'll say about that is the person you name as executive doesn't have to be the same person who handles your funeral, doesn't have to be the same person on your power of attorney or your medical directive, because they may not be able to handle it. You know your family members, and communicate to them that you have these plans and what you want them to do, because they will tell you whether or not they want to do it. But like more importantly, as I think Crystal gave the example earlier, if you're worried about a family member going after your money, then yeah, that's not the person you want. So it doesn't have to be the same person. It doesn't have to be your oldest child. Doesn't have to be, mom or dad. It's your will. You choose that person who you want to be in charge.
So the putting of the person in charge, the executor or the executrix, is probably the most important thing in your will. You want to leave somebody in charge. If you have no stuff, even if you have no stuff, let's say you pass away, there's a wrongful death action. If you name somebody in your will, then they can hop into your shoes right away and pick up that wrongful death and sue, on behalf of your estate for something that happened to you, a car accident, something that was fatal that caused your death. Also, as Deputy McDougall said, you also want that contingency, because not only does it avoid fighting between family members or residuary legatees, those are the people that are entitled to take under your will. It avoids fighting between them, but additionally, it avoids them having to get a bond. So let's say you name one person to be your executor, John Smith. and you name no alternate, no contingency in case John Smith is unwilling, unable, passes away or something, then whoever comes up next now has to be bonded. That means they have to go to an insurance agent, be credit worthy, have no criminal history, so that they can post money, file a bond so that they can serve. And if they don't resolve your estate in a year, and when there's real property like houses, condominiums, businesses that have to be sold, sometimes it takes more than a year. So you have to keep paying out these premiums, which come out of the person's pocket initially, but then it's essentially come out of the pocket of the estate beneficiaries, and you don't want to do that. So you want at least one executor, executrix, and at least one alternate, a contingency.
Fantastic. Thanks, everybody. That's amazing. I have two more questions here, and I don't know about everybody else listening out there, but I'm getting so much information, and I just applied for college again right now because I don't know half of what's happening here, so I'm going to go back to school, y'all. Anyway, I got two more questions. Also, forgive my screen. Like I said, I'm using borrowed equipment and it keeps flushing out. It looks like I'm at the center of the sun. Okay. Here we go. The next question, again, from the White family, is about claims. If there is no will, how does New Jersey's law of intestacy apply to only the surviving blood-related nieces, nephews, and any grandchildren? What needed information, proof, certificates, papers, and or statements are needed for the surrogate court so the claimants can forward to the state of New Jersey? That's a big question. If you need me to read it again, I can, but I'm sure you're all smarter than I am. I'm just going to be quiet.
So it's a big question. We have that all the time. And when you say the new state of New Jersey, I'm going to presume you're talking about to unclaimed property. I'm gonna answer it. I'm gonna answer it this way. Depending on where your family member passed away, I think it's better for that question, contact the surrogate court, because we can give you all the information, because there's a lot of things that you may or may not need, depending on where you are in terms of the family. But I will kind of touch on something that people think that strangers can't come and apply to be the administrator of an estate. In New Jersey, they can. If a family member doesn't come within 40 days after their death, anybody can apply. I will speak for Essex, but I think most surrogate courts in Jersey does this. We won't appoint you because we don't have the capacity to take testimony. So we actually send you on to the Superior Court judge. So that judge can determine whether you fit. Because most of the time, the individual that's doing it is a creditor, and it's a conflict. And so we let the other judge make that determination. But in terms of your question, just call the surrogate court. We'll, whether you're here, Essex, Passaic, or whatever, they'll go over all the information you need if you're talking about unclaimed property, what you need so you can claim that property. You got something, Crystal?
Yeah, so Devera, I'm gonna ask you a question, right, based on this. So first, the first part of the question was about the laws of intestacy, and to the White family, shout out to the White family for knowing great questions to ask. Hello, that's number one. Number two, the laws of intestacy for everyone else. That's where whatever state you're in has a statute that says what's going to happen and where your stuff is going to go if you die without a will, right? And so where that stuff goes depends on your family situation at the time. If you have no children and you were married, but you have a parent that's living, for example, there could be a division of your estate between your living parents and your spouse. Same thing if you have children outside of your marriage, there would be a percentage to the children outside of the marriage and then a percentage to your spouse. So the circumstance in New Jersey will depend upon how your stuff is divided. But what I heard the spirit of that question to be is what proof is needed to show that the cousin is really the cousin or the niece is really the niece. And so I'm really interested in hearing from the two surrogates as to what your offices require with respect to that.
But that's why I said call the office, because it may vary from surrogate to surrogate. Some may ask for more proof than others. Right. I've heard, and I think I've heard it from you, Crystal, that we're kind of particular in Essex County. Yes. So it depends on, really it's the judge's discretion and the comfort level. But I think most surrogates will probably agree that if you come in and you're this long lost cousin, they're going to ask for a lot of information, because at the end of the day, the responsibility of the surrogates court is to make sure that the individual who's getting appointed is the person that the law allows to get appointed. Distribution, we don't really get involved in the distribution component. We'll talk to you, like Crystal just mentioned, the breakdown. We'll have a brief conversation with you, but the surrogate court is not responsible for distribution. The statute, is intestate statute, tells you how to do that. I will say this, and what we always express to people too, is sometimes you may, if you get appointed the administrator of an estate, even if you get appointed executor, you may need to get an attorney, a lawyer, a CPA, or some professional to help you out. So it's a job in itself. So don't be afraid to ask for help, especially if there's money in the estate, to hire that professional. But to go back to the question, yeah, I think it varies from surrogate court to surrogate court. Some may ask for more than others. I'll let Judge Toledo chime in on that.
So there's just so many moving parts going on here. So going to one of Surrogate McDougall's points with respect to a non-family member applying, it is true, any fit person may be appointed by the Surrogates Court after 40 days, but it's not just an appointment like that. We notify the Attorney General's office, we notify the State of New Jersey Department of the Treasury. So there's a lot of things going on before that person can be appointed. And it is true, if it's a creditor, sometimes it's a funeral director or somebody, a creditor who wants their money and they're seeking the appointment, we are unlikely to give it to you because of the whole dual role, the conflict that exists in that basically you're applying to serve yourself, and we're afraid that once you pay yourself, then you won't want to finish with the distribution of the estate. So that's the problem there. With respect to what proofs are involved, there you make the inquiry. The person is under an obligation to make an oath. We ask for their ID. We ask them for a list of next of kin. All those family members that are named have to be notified in writing that there's a will that is seeking to be admitted, or that an application has been made, so that they can be put on notice to contest if they so choose. If they do choose, they can do one of two things, which is they either file a caveat, which says, hold on a second until we can figure out what's going on. I need things, put on hold, or they can just go straight to an attorney, somebody like Ms. West, to file a complaint in order to show cause so that they can be heard with respect to objecting to that person's appointment. Now, with respect to proofs, we make the inquiry, we ask the questions, and that they make statements under oath and sign our documents under oath. However, we don't ask for a DNA test. We don't ask for, 23andMe to see if there was, a bloodline or not. We don't. But again, the idea is that we do have to appoint somebody. The 40 days seems kind of short, but the idea is you want to get estates moving. If you were so close to that family member, why haven't you gotten things moving? Because you have houses that sit idle, pipes that freeze and burst, lawn that grows too long and upsets your neighbors. So we want to get estates moving. So if the family doesn't come forward, but somebody else does, we may not appoint that person, but we'll appoint somebody, an attorney, maybe that person, maybe not, depends, what their role is, just to get things moving. But it does give the family members an opportunity to object, a limited opportunity, but there's an opportunity to object. So to go to your nitty-gritty question, Ms. West, what proofs? You swear under oath, and you give us a list of next of kin, and they're notified in writing.
Can you real quickly explain the term, because you said caveat? So if you can just explain that to people.
A caveat means, we've always heard that caveat emptor, let the buyer beware. Well, caveat, the word caveat means beware. So when you file a caveat, it's a $25 fee to file a form. We call it a caveat, which says beware, don't move any further. So the surrogates court is a court of no contest with administrative proceedings. If you have somebody saying beware, I object, there's further things that we have to work out here, then we're no longer going to proceed or admit that will into probate, because clearly somebody has a concern. Maybe you're saying that that's not the true last will and testament. There was one that came after it. Maybe that was a fraud. Maybe there was duress, whatever it is. So that person files, and you don't need an attorney for that portion. For a caveat, it's just a form and $25 to stop the process, and it buys you time, because the probate process, if there are no objections, it moves pretty quickly. So the good part is it moves pretty quickly. The bad part is it moves pretty quickly. So if you fall asleep on your rights, you will have a lot of untangling to do, and a lot of you have to prove just cause so that you can get into court if you've been untimely in trying to exercise your rights as a beneficiary.
And there are two things that I want to highlight for this question that are important. Since it's talking about the laws of intestacy, it's telling us that the person didn't have a will. And so once someone has stepped up and has the authority from the family, okay, and I'll explain that in a second, that's needed in order to serve. Authority from the family is, let's say that the person who passes away has 5 children. One child is not going to be appointed over the other 4. Right? They all would need to agree and consent that the one who's stepping up can serve. And if there's a question as to whether or not everyone is going to consent, then we're going to a superior court judge to appoint someone. But once, let's say, we have that person who's going to be serving on behalf of everyone, the surrogate's office is not going to appoint them until they are bonded. And a bond is essentially, think about it like bail bond, right? So there's an insurance company that says, I'm going to insure the actions of the administrator. What that means is if the administrator does the opposite of what they're supposed to do, they pick up and they run with the money. They don't pay the creditors. They don't pay the beneficiaries. The creditors and the beneficiaries can claim against the bond to get their money, but then the bond company is going after the executor, in this case, the administrator, in order to get their money back. The point is, serving as administrator is a job. It comes with responsibilities, and it comes with expectation that if you do not act in a certain way, you can be punished for it. That said, how does all that tie to the white family? The question about what proofs are needed, it's not so much about what proofs are needed to be appointed. I think you're asking what proofs are needed in order to be a beneficiary, right? And in that context, the onus is really on the administrator to make sure that they're sending the money to the right person and to the right people. And so if there's a cousin that they don't like and the cousin's been estranged and they're just going to not divide up the estate for that cousin because homegirl hasn't showed up in 2 decades, that's not okay. Even that person would be entitled to a portion, and it would be on the administrator to do that.
And there's something called the release and refund of the bond, right? So you sign a form, you get out this bond so you can serve, right? And so how does the insurance company know that you've already made all your distributions? Well, everybody who receives a distribution from you, a $10,000 check, a $5,000 check, they're going to sign a release saying that they received X number of dollars, that they release you from obligation. And if another family member, like that cousin with the bad attitude that you don't want to give money to, that you didn't know existed, but I guess the administrator did, if she were to surface, that you would refund the estate your pro rata portion, your proportionate portion of the estate, so that she can be made whole. Because while the insurance company may reimburse on the claims, don't get any ideas, because 2 big burly guys will show up to your door and get the money out of you one way or another, because it really is like a bail bond. They may pay the money, but they want the money back.
Let me jump in for a second. Thank you, Judge. A few things. I wanted to let everyone know that we're going to extend the time another 15 minutes because information is just this critical, and there's a lot of questions that came in, and we do appreciate your participation. Howard, we have another question from a very special person. It's just my wife. She just has a question. So if you see the question as a follow-up, I do want to take a point of privilege. If you don't mind asking that question, I'm sorry, Devera, I apologize. I'm married. There's a question in your inbox by Darren Kinney. Can you please ask that question?
By Darren Kinney, not the one from Denise.
No, it starts with what happens in the case of.
Okay, let me look. Give me 1 second. Sorry. Give Give me 1 second here.
And I do apologize for disrupting the flow, but
Is that the criminal activity question?
it is that question.
Okay.
You already see it?
How to keep the wife happy.
Absolutely.
I see. Let me read it. I see it, Harold.
You see it? Go ahead.
Yeah. What
Oh
happens?
yeah, I see it right here. What happens in the case of a criminal activity? Yes. You want me to read it?
Yep.
I want Harold to read it, if you don't mind, Harold, please.
What happens in the case of criminal activity if the person intended to receive the stuff is imprisoned or awaiting trial?
They still get what they're going to get. Now, if they're in prison for killing the testator, the person who passed away who had the assets, now there's actually law, statutorily, they are precluded from benefiting from their crime. So if they're in jail for killing the testator, they're not getting anything. If they're in jail for whatever else, they're going to get what they're going to get. They're still entitled to it.
And let me clarify. Not that they're just in jail; they have to be convicted of the crime. Just being accused of it and being imprisoned isn't enough, because yes, the law does presume, it's a legal presumption that if you killed the testator or the because it could be intestate or the decedent, then what happens is it looks like the court looks at, or the law looks at, you predeceased them, so you're not entitled to anything. So, but you have to be convicted, not just in jail, because you can be accused of anything and go to jail and not be convicted. So you have to be convicted of that crime based on what Judge Toledo said. And I hope you have happy, Jeremy, that Harold answered your question. Asked your question.
And I think she's a fan, but from my perspective, I just want to say that when we have beneficiaries who are in prison, and we're doing an estate administration, the process continues from the legal standpoint. I mean, the difference is I can't just mail a certified letter to the person in prison for them to sign in the presence of a notary. I do have to contact the warden. I have to confirm that the warden is going to assist them with the notary. I have to send it directly to the warden. So there are more steps that are needed, but we can press on.
Fantastic. I have one more. There are many other questions. I have one more early question, and this is from Denise. And it says, an individual that has been married for over 36 years, not divorced, can a spouse prepare a will that can leave property obtained during the marriage be willed to someone else? During the course of the marriage, the spouse took the other person off the deed and said it was in the best interest.
So that question reminds me of a joke, right? So husband and wife are married for 30 years. He passes away. He's off in heaven. She's so sad. She's driving home from the funeral. She crashes, and now she dies too. She sees him in heaven. She's elated. She says, "Darling," he says, "it was till death do us part. A deal's a deal." Well, the joke is on him, because there's something called the spousal elective share. So what does that mean? You really truly can't, not at the core, not in effect, disinherit your spouse. You can disinherit your children, but not your spouse. A spousal elective share is a particular portion that you are due. So let's say you're married to Elon Musk, who's worth $100 billion, and he left you, $5 million. $5 million sounds like a lot of money, but compared to his $100 billion, it's peanuts, right? So you can say, thanks, Elon Musk, my husband, but no thanks. I'm going to make a complaint in court in order to show cause for the spousal elective share. So what is that amount? That amount is roughly, I don't want to get too technical, but 1/3 of the augmented estate. That means that, you have to pay it's 1/3 after you have paid the funeral costs. That means that it includes any sudden moves or transfers of property in the last 2 years before the person passed away, right? So if 6 months before he passed away is when he did that deed transfer thing, the value of that house will be considered part of the value of the estate. So the spousal elective share protects, because it's not till death do us part. You know, that whole in sickness and in health, those are not vows. Those are terms, contractual terms. You're going to take care of your spouse, but there are some conditions. You can't be estranged. So you have to be living together under the same roof at the time of death. You can't sleep on your rights. If you sleep on your rights in the surrogate's court or in the probate court, you have a problem. So you have a limited window, and I believe it's 6 months to make this claim, to file this complaint. After that, your hurdles like triple for the spousal elective share. Before that, listen, you just have to make the application. And then the final thing is, to some degree, it's needs-based. So if you're Mrs. Elon Musk and you already live in a massive mansion and you have all these assets, you may only be limited to whatever's in the estate. So the 5 million is the 5 million. So yes, and generally speaking, if you're not married to Elon Musk and you're not independently wealthy, you are entitled to a third of the augmented estate when you're the spouse. Augmented estate, that means everything. I hope that helps.
And that the deed part is, Crystal, could you answer the deed part, the husband taking off the deed? That's an interesting part of the question, if you don't mind.
So, okay. So assuming that the property was jointly owned, absent fraud, it's not possible for one person to just simply take you off. Whoever is changing a deed, both of those people would have to sign that new deed, right? Transferring it from husband and wife to husband. So assuming that she came off, you're either saying she did it because she didn't know what he was really up to, right? Or he forged a signature. Forging a signature would be a crime, right? So that's something that would be voidable. That would be a transaction that would be voidable. But if she voluntarily transferred the house out of her name for a reason, a host of reasons, can it go to someone else? It can. And this scenario that we're talking about, this 36-year marriage thing, applies for people who are estranged. So we've had situations where they were together back in the 70s and they separated and did their own separate lives and never came back together and never divorced. And sometimes it's not cheaper to keep her or cheaper to keep him, because we'll get it at death.
So, but in this instance, though, it sounds like she said that both of their names were on it, and then subsequently only his name was on it. Right? Is that what you were saying?
It looks like, yeah. Well, it looks like one person took another person's name off.
Right.
For the best of the I don't know, the best of the home, or but they said it was for the best. I don't really know what that means, but yeah, it looks like one person took a name off the deed.
Right.
So that's still a probate asset as opposed to a non-probate asset. Non-probate asset would be like a life insurance policy with a designated beneficiary, or a bank account, for example, that has a payable on death designation.
It could be, Judge, but remember, if the property was bought by a husband and wife by operation of law, it automatically should have went to the other one. So there should be no reason to fight, as Crystal said, if it was done fraudulently, which is possible. And I think there may be another question which kind of leads into like the mortgage thing, but people do it for mortgage related things, take somebody's name off to kind of, because my credit is bad, so I'm going to.
Sure.
So I guess that can lead us into if you want to read the question about the mortgage, Harold. But
I was just about to say that.
Yeah.
That leads right into that question. If you still owe a mortgage, if you still owe on your mortgage, does the insurance automatically pay off the home, or does someone have to be appointed to do that?
Would we like to count to 3 and answer that question together? 1, 2, 3. No. So this goes back to my comment earlier when I said, if you have a desire, you should specifically say what that desire is. When it comes to life insurance, and we often see this less about a mortgage and more about a funeral, but it applies with a mortgage too. They'll say, oh, well, I have this life insurance policy to pay off my mortgage, or I have this life insurance policy to pay for my funeral expenses. Well, whomever you've named as the beneficiary, as the designated beneficiary of that life insurance, is who's going to inherit that life insurance. And they don't have to use it for the mortgage, and they don't have to use it for the funeral. If, on the other hand, it's your intention that that life insurance only be used for that reason, then we go to that honorable mention document I talked about earlier called a trust. And so we have a trust that says, this is the such and such life insurance trust. This money, my trustee shall obtain the benefit or the claim at the time of my death and use the funds as follows. 1, pay my funeral. 2, pay off my mortgage, right? Then that life insurance would be designated for a specific reason because you've sent it to an invisible box that has an agreement with someone else that specifically says how they're going to spend it. But if you leave your life insurance policy to your daughter because you want her to bury you with it, the funeral expenses are the first thing that gets paid from your estate. And life insurance is not payable to your estate unless you just didn't name a beneficiary at all for that policy. So be very clear and very well intended as to where you want your stuff to go and how. You want life insurance for funeral? Then we got to take some additional steps to make that happen. And sometimes we can prearrange funeral services, which is also a very beneficial portion of people's estate planning, particularly later in life, because it does avoid some of the heartbreak, right, that's associated with planning someone's services. So you kind of plan your own. You can write your own obituary if you want to. You can be as granular as you like to help your loved ones.
That's fantastic. So it seems like we're a couple of minutes out. I'm gonna ask 2 more questions. One you don't totally have to answer yet, and then the other one we can answer. The first one that you don't have to answer. It says, will you provide a checklist of common documents for estate planning, a template for wills? And that was from Stacy Smith Rogan. So maybe we can talk about it at the end.
So I already have that on my website. If you go to www.porzioplanning.com, that's porzioplanning.com, there are a ton of webinars and blog posts about all of these different topics that we've discussed today. So that should get you started. And then the surrogates offices also have fact sheets when it comes to being appointed in certain capacities and also filing some court applications for things like guardianship.
And then the last question I think we're going to have, someone asked me, do you update your will? And if so, how often? And it's a question I think comes up for a lot of people. They get these wills that are like, oh, this was done in 1990, and then they've done again in 2004. And so how often should a person update their will, or should they?
Well, I think that they should look at it at least every 3 to 5 years. But I tell my clients, whenever life happens, someone passes away, someone gets married, you know, your best friend who you appointed as your executor moves, just to make sure that it still says what you want it to say. A lot of people will have wills that still leave their money in trust for their minor children, and now their kids are in their 40s. Does it matter that it said they were going to have money in trust until they're 25? No, the rest of the will may or may not still be consistent with what you want, but it's important to take a look at it. When it is critical to call your attorney about your will would be when all of your friends on pick your favorite news, entertainment news, right? So that could be CNN, that could be MSNBC, or that could be Fox. When all 3 of them are talking about something that is happening in DC with taxes, whenever you hear the word taxes, it is worthwhile to pick up the phone and call your estate planning attorney to see if it applies to you. When they talk about it on the news, they highlight, you know, things that are for high net worth people, you know, but admittedly, whenever there's a tax law change, it impacts all of us. So it is important to touch base whenever you hear that something is changing with taxes.
And that's an excellent question. I just want to add to it. As you're reviewing it, and if you think you want to change something, do not cross it out. In New Jersey, technically, when you cross your will, and Surrogate Toledo mentioned it earlier, technically you have revoked your will. It no longer is null and void. So, there is some discretion. Some surrogates will look at it. If somebody, is supposed to spell their name with the E at the end and didn't do the E, they may let it go. But you shouldn't be crossing out because you wanted to take a son off, you cross it out. You're not supposed to cross out a will, because if you do, we have to send it on to the Superior Court probate part judge for them to make a determination whether or not we can probate that will. And so what you want to do is go to your attorney and talk to your attorney. And your attorney, this day and age with technology, they can draft a whole new will, or they can do what's called a codicil, which is just it's an amendment to the will, and you can just amend that particular provision in the will that you want to change. And that's pretty much all I have to say about that. But that's an excellent question.
Thank you, everyone, for the information that you provided this Sunday evening. We truly appreciate it. There's a famous quote by a gentleman that played in The Best Man by the name of Andre Lloyd, and he said the following: "Defining yourself for yourself, or be eaten alive." And pretty much this is the quote that tells us exactly what this conversation is about, as it relates to family, relates to the legacy that we leave behind, relates to the sort of the work that we do now, and to make sure our family, our institutions benefit from the things that we've done. And Harold, I appreciate your openness, to share your family story. Also, your openness to share, the fact that you still looking to get a will, because you're like like a lot of Americans, we believe we have a lot of time on earth, and we say, well, we'll do it next week. And procrastination is one of the biggest, impediments of getting this sort of paperwork done. And again, we truly appreciate, your time. Crystal, like always, you have done a dynamic job providing us a wealth of knowledge and information. If you want to reach Crystal, please go to her website, Porzio Planning. Am I saying it correctly? PorZioPlanning.com. Please reach out to her if you want to answer any more questions or look for services. She gave you an hour and a half of information. So from this point going forward, it's between you and her. Judge Toledo, thank you again for, every time we ask a question, hey, can we partner on an outreach, or partner on an initiative? You always, step forward. You never hesitated. You just say when and where, and how much time do you need? And so we appreciate you and the work that you've done in Passaic County. You have provided leadership and knowledge, and I've learned a lot from you because of you. Thank you for your service, and we truly appreciate you. And DeVero, thank you again for another outstanding, excellent job providing information, keeping us on course, on track, like you always do. Again, I truly appreciate the work that you've done, in Essex County. Thank you, everybody. And also, I wanted to say one more thank you to Tara Dardell from the Tara Dardell Group, who is ensuring that this broadcast is presented on all the platforms, and who make sure that we are doing the work that we said that we're going to do. So thank you. Have a wonderful evening. I truly appreciate you.
Good evening, everyone.
Good evening.
Good evening, everyone. Thank you all. Thanks.
Thank you, Harold. Appreciate it.